When we're talking about custody, we're talking about where does the child or the children reside. Okay, and there are different types, and we really refer to it as, again, in the courts, they call it residency. Where is the child residing? So you may have primary residence, primary custody, shared custody of the child. Those are the two types. If it's shared and the parties either agree or the court finds that each party contributes substantially, equally to the child, then there may be no child support order entered. If one parent has primary custody or residency of the child, then child support will be ordered, and the non-custodial parent will have to pay that child support. Custody is more than just where does the child live. You also have to take into account visitation for both parents, because we've got holidays, we've got birthdays, we've got important family events, and those all need to be taken into account when you're talking about custodial arrangements for the children. Okay, who gets to visit the child when? Where does the child spend the summers? If dad lives outside the state of Maine, is the child going to dad's house for 2 weeks for a summer vacation, or is the child staying with mom on the lake for a 2-week summer vacation? All these things could and should be negotiated, but it's really more than just where does the child primarily reside. It's also about visitation and making sure that the non-custodial parent is being treated fairly, because the courts believe, as do I, it's important to have both parents parenting and raising that child, even if it's done in a separate fashion, to the extent possible. When the court makes orders concerning children, they make those orders in the best interests of the child. What does that mean? That means it's not in what is in Johnny's interest or Joni's interest. It means the best interests of the child, because courts recognize that when you're going through a custody dispute or a divorce involving children, oftentimes what you're raising are issues that are in my parental best interests, or what I think should be done for the child as the parent. And the court is only looking out for the best interest of the child. So you may think that you're the best parent, but based on specific situations in your case, the court may determine the best interests of the child lie with residing with the other parent. Maybe you've already left the state and you want the child to come with you, but the child has been established in that school system. Maybe you are a great parent, but the court's going to look at this. What are the best interests of the child? And uprooting that child from their established community and school system and support system probably is not in the best interest of the child. And that's how the court is going to look at this case when discussing parental rights and responsibilities and custody. Can you modify an existing custodial arrangement, i.e. child custody agreement? The answer is yes, but you must show a substantial change in circumstances. What constitutes a substantial change in circumstances? Again, it's fact-based, but here are some examples. There's been domestic violence in the home. There is a significant alcohol or drug problem that's been discovered for the custodial parent that's now potentially endangering the welfare of your child. There's been a significant financial change in circumstances for one or the other of the former spouses. One parent is seeking to relocate. In order to do that, they would need to modify the custody agreement. These are just a few examples that are fairly common when someone comes to us asking if they can modify a child custody agreement. One of the things you want to look at too is what's the purpose of the modification, what's the likelihood of success, and what's the cost. When it comes to children, I think cost kind of goes out the window for most people. But I think it's still a factor to determine how much is it going to potentially cost me to duke this out, and more importantly, what's my likelihood of success. And at the end of the day, court is still going to look at this through the lens of best interests of the children. So just keep that in mind. Here's a common question. You've been divorced for a while. You're tired of Maine. It's just too many bad memories after this. Now you want to move to California, but I also want to take my child with me. Can I do that? The answer is maybe. It's going to be, again, determined based on the best interest of the child. And you must first file a motion in order to relocate the child or with your child, and the court's going to have a hearing on it. So if it's more than 60 miles from the other parent, you've got to get permission from the court. If you just take your child and run off to California without the court's permission, your spouse is probably going to call law enforcement to say that your child was kidnapped. And there are a number of significant legal consequences that will befall you, all of which are negative if you choose to do that. The best thing to do, even though it's not convenient and it can be expensive, is to file the appropriate paperwork and motion with the court, put the other party on notice, and then there will have to be a hearing, and the court will make that determination. Don't you make that determination on your own. If you've got questions about child custody issues in a divorce or post-divorce judgment proceeding, give the attorneys a call at the Maine Divorce Group. We're here to help you walk through this process and get you to a better place.